So I'm now going to call on you, Wai-Pong, to open this session up with a statement, really, an explanation as to how this all came about in the first place, why it all came about in the first place, and why you think we should all be listening about it and taking an interest in it. I hope that's a sufficient introduction for you. And so I'm going to give the floor to you.
Thank you very much, Margaret. Can you hear me?
I can.
All right, and I take that by extension, and everyone else can hear me. A very good evening to all of you in the UK, and it's midnight, well, slightly over midnight. Just indulge me for the next 10 minutes as I bring you on this short journey of mediation. When this first invitation came out, it was a bit intimidating to talk about the future and the issues, and I have to provide a health warning. I didn't do much research because the India-Singapore Mediation Summit was held on the 17th of July, providing an enormous mountain of content, and I'm not ashamed to say that I took a lot of content from this excellent speech made by the Honorable the Chief Justice Sundaresh Menon on this. So much of what you hear owes its origins to his speech, but of course suitably modified for our audience. Let me start by talking about the Singapore Convention on Mediation, or the Singapore Convention in short. What is it for the uninitiated? Essentially, it is a uniform and efficient framework for the international settlement agreements resulting from mediation. I think that's the important definition. And it applies to international settlement agreements resulting from mediation concluded by parties to resolve a commercial dispute. Every word of it has its own particular meaning. And the purpose of this convention really owes its purpose to facilitate international trade and commerce. How it does so is by, it is there to enable disputing parties to easily enforce and invoke settlement agreements across borders, something that characterizes a lot of the trade that goes on today across borders. And the effect of the convention is that businesses will benefit from having mediation as a dispute resolution option, in addition to the channels of litigation and arbitration to settle their cross-border disputes. A little historical perspective at this moment would be helpful, I think, and I'd like to share some 5 points with you. Mediation always has been around for the longest time. A lot of people will know that. Some will purport that it's intuitive and native to Asian cultures and societies, but you know, this notion, it's not exclusive to Asian contexts. Although mediation is long on historical origin, it was often seen to fall short in terms of widespread acceptance as an internationally recognized and adopted form of dispute resolution, so much so that sometimes it's confused with meditation. The procedures have not advanced, to be honest, and morph with times to reflect modern business and social practices. So, you know, it wasn't until the last sort of 3 to 4 decades that they have been formalized internationally. And the result of this lag has, you know, caused a lag as well of mediation behind arbitration in terms of recognition as an internationally recognized and mainstream ADR, which is short for Alternative Dispute Resolution, and largely because it would seem to lack international enforcement teeth, and I'll speak about that very shortly. But coming back to Singapore, like all emerging nations, we suffered the pangs of growth and nationhood, and you know, part of the stirrings of a new nation, promoting mediation as a mainstream ADR became one of them. there was a concerted movement in Singapore to revive the practice of mediation, and that began to stir in the 1990s. It was driven by four main objectives. One, check the growing trend of litigiousness that was taking hold in the society. Two, provide a more economical and less adversarial way to resolve conflicts, and in this way to enhance access to justice. Three, to ease the judicial caseload. And four, to promote recourse to amicable and harmonious means of conflict resolution, which is seen as being consistent with Singapore's culture and values, which again, I want to stress is not exclusive to us. And many societies share those cultures and values. But, you know, in a nutshell, all these four objectives are valuable too, and it's consistent with the growth of a pluralistic society in Singapore's modern history, which of course, those of you who are familiar with our little red dot traces its origins from a rural trading post to what is often today seen as a sophisticated modern and urban society. So in tandem with this transition, a perceptible shift began in the belief that adjudication, litigation ought to be always the mainstream and default way to resolve disputes. So the modern perception that mediation could provide a truly viable alternative helped to move the needle for a maturing, knowledgeable, and more discerning society, aspiring for a better intersection of mainstream and alternative dispute resolution methods. So all these aspirations, briefly translated, they breathe new and fresh oxygen into the development and growth of mediation through these three steps, which, you know, in the beginning in the 90s, Singapore began to establish more formal structure for mediation by starting with this domestic legal landscape. In 1994, ADR was officially introduced into the then subordinate courts, now known as state courts, to promote and facilitate non-adversarial methods of dispute resolution. And in 1997, Singapore established the SMC, which is the Singapore Mediation Center. And that's focused on dealing with commercial disputes and with promoting the use of mediation outside of the court system. So these concerted and sustained efforts, they have contributed significantly to the successful revival of mediation within our domestic landscape. So do we have a case for mediation as a mainstream ADR? That's a question that is often posed not only to myself, but to many mediation practitioners. And let me spell the ways, you know. There are four ways I can think of. Parties can resolve their disputes through a tailored process in a flexible yet confidential manner, while also having to expend less time and money when compared to the other more formal modes of dispute resolution. Mediation is highly effective. Statistics gathered show that more than 70% of mediated disputes are settled often within the day. And this is so even for the more complex cross-border commercial cases. I know this sounds quite far-fetched to the uninitiated, but both Jonathan and myself, if for one of the other examples, both of us can attest to that. And even in circumstances and situations where settlement might prove elusive, the parties having undergone mediation are much clearer as to the issues and interests at stake because they've been crystallized. And so they are better able to tailor and streamline subsequent processes to manage the outstanding issues in the best possible way. And lastly, mediation being non-adversarial and interest-based, it can help to preserve a functional relationship between the disputing parties. And in jurisdictions such as ours, which is no different from the UK in many aspects, it's a premium placed on harmony, trust, good relationships. And mediation's ability to enable parties to manage and resolve their differences without taking adversarial and overly hostile positions, something that Jonathan likes to allude to, parties hurling fireballs across from their own established fortresses, that can result in zero-sum win-loss outcomes. All this cannot be understated. So there you have it. You know, we did the groundwork, and where we are now in the trajectory is that we are heading towards maturity and internationalization of our mediation landscape. The 6 points I want to talk about. First, Singapore's domestic experience provided the foundation for growth towards maturity and paved the way forward for internationalization of its mediation services. The working group was established in 2013 to recommend ways to develop this, and they foresaw that the growing complexity of cross-border in commercial disputes would inevitably also rise. To internationalize, Singapore established the SIMC, or Singapore International Mediation Center, in 2014, and it has grown quite a bit. The fifth point I want to make is that in 2017, in terms of legislation, Singapore introduced the Mediation Act, and that forms the cornerstone for our mediation framework, providing clarification for common law rules of confidentiality and admissibility in the context of mediation, and allowing parties to seek a stay of court proceedings. The Act also provides, amongst other things, enforceability of out-of-court mediation settlement in the same manner as an order of court. And this is vital if we are to promote the willingness of parties to engage in the process of mediation and to ensure that they adhere to the terms of the settlement agreement. And the last point is the standards and staff. This is a spirit of built-in dynamism in terms of training and upholding of standards, and to ensure that fresh blood brought in will uphold established standards. I now turn to the Singapore Convention 2019 itself. The combination of all these efforts that I spoke about earlier, they led to the ultimate construct of the convention. 7 points to highlight. It was adopted in 20th of December 2018 by Resolution 73/198 during 73rd session of the General Assembly of the UN. It became open for signature on 7 August 2019. 46 states signed on that day. It entered into force on 12 September 2020. 54 countries have already signed the convention, including some of the largest economies in the world: the United States, China, and India. And just last month, Brazil joined their ranks. 6 countries have also ratified and approved. There is a noticeable wrinkle to the smooth progress so far. And that's something Jonathan and I agree on many things, but this one we cannot agree on. Why has not the UK and EU not signed on? I'll leave this 2 questions if some of you would like to raise. So I'll end by talking about the deliverables. What are the deliverables of the Singapore Convention? First of all, it's poised to radically alter the future of mediation, not just in Singapore, for which the convention is named, but globally. Its most important contribution is the confidence and reassurance it provides that international commercial mediation can result in binding and internationally enforceable outcomes. And in so doing, it alleviates a key concern that has long acted as a drag on the growth of mediation as compared to arbitration, that in the end, mediation outcomes are simply fresh agreements that's just as viable as the agreements that gave rise to the disputes in the first place. And enforceability was identified as a top factor influencing respondents' choice of dispute resolution mechanisms. So with the convention, I would close by saying that users now can have the best of both worlds in terms of speed, cost savings, with widespread enforceability. Ladies and gentlemen, this is a compelling proposition for businesses seeking to lower the legal risks of their international ventures and investments while also containing their expenditure. I'll end on this note. Thank you very much. Over back to you, Margaret.
Wai-Pong, thank you very, very much. I think taking that forward, the history is very helpful to know, and we may come back to that in due course. But I think that in terms of the deliverables, that was a very interesting section that you had there. So if we look at what is the underlying aim of the convention, I think, if I may say so, you covered that very well. Jonathan, would you have anything to add that you'd like to highlight at this point on that?
Yes, thank you, Margaret. Wai-Pong kindly said, and I agree, that we agree on most things. But just to comment about the history, it was brought home to me. I had the good fortune to do postgraduate studies in France, and there was a wonderful professor called René David, who spent most of his life as a professor in Paris, and for his swan song years back to what was his home area, Aix-en-Provence. And he wrote a book called Les Grands Systèmes de Droit Contemporain. And in that book, comparing great systems of law, the message was very clear that in the East, the Far East, you have the amicable means of dispute resolution compared with the less amicable adversarial means in the West. And so, yes, in terms of history, of course, mediation rests a lot on the Far East, but my suggestion is that modern ADR actually has its birthplace in the United States. And the reason I say that is because it seems to me it's no surprise, if you like, that modern ADR grew up where the twin evils of cost and delay are at their most acute. But anyway, I think we can all agree that there's plenty of mediation everywhere, and that what we're talking about with the Singapore Convention is a means to propel mediation center stage with now for the first time enforcement internationally of mediation settlement agreements. And actually the convention, sorry, a long-winded answer to your short question, Margaret. The preamble to the convention states its aim very clearly, and that is, and I quote from the preamble, the development of harmonious international economic relations. So that's what this convention is all about, sets out to achieve.
Thank you very much, Jonathan. So on the one hand, we've got harmony, and on the other, as you mentioned just a little bit earlier, particularly in the US, but it's not unknown over here, we've got the issue of cost. Moving on from that, you've referred to the convention, and so I'm going to ask you now to deal with the scope of application of the convention. Wai-Pong, would you like to lead off on the scope of application of the convention, and then I'll ask Jonathan again to comment.
Yes, thanks, Margaret. I mean, the very first statement I made is that the convention exists to provide this framework for agreements resulting from mediations, and the mediations, all the roads point to commercial dispute. So that, in a nutshell, would be the focus of where the main thrust of the convention is directed. So, for one of an example, it will not apply to family disputes, settlements reach out of family disputes, or something of that genre. Maybe Jonathan would like to add on to that.
Yes, over to you, Jonathan.
Yeah,
my dear learned friend.
Okay. Yep, Article 1, and I'm the sort of nuts and bolts man, I guess. You know, Wai-Pong has been philosophy and blue sky and history. I'm sort of nuts and bolts. Now, Article 1 states as initial requirement that it has to be an international mediation. It's international mediation that we're talking about. And it goes on to say what qualifies as international mediation, namely either that there are at least two parties in different states, or if the two parties are in, assuming it's a two-party case, that the two parties are in the same state, it can still be international if the state in which a substantial part of the obligations under the settlement agreement is performed, or the state with which the subject matter of the settlement agreement is most closely connected is in a different state. So you've got parties in different states, or substantial part of the obligation to be performed in another state, or subject matter of settlement agreement most closely connected with another state. In those cases, you have what qualifies as an international settlement agreement, which is for recognition and enforcement under the convention.
Right, now that's what it does apply to. There are some specific types of dispute which are taken out of the application of the convention. Would you like just briefly to speak to those? We've already heard about family disputes.
Yes, did you want me?
I think, yes, sorry, Jonathan. Yeah. I think in particular, there's a particular exception, is there not, about consumer dispute?
Yes, this is dealt with in the second paragraph of Article 1, which says in terms that the convention doesn't apply to settlement agreements. And firstly, it's consumer cases, then it's transactions of personal, family, or household purposes, and then also relating to family, inheritance, or employment law. So those are all specific exceptions to the applicability of the convention.
Well, thank you very much. Is there any particular magic that we ought to know about in the word mediation for the purpose of the convention? Jonathan.
Yes, again, that's a defined term. And it says means a process, irrespective of the expression used, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons, quotes, the mediator, lacking the authority to impose a solution upon the parties to the dispute. And I actually have a question for anyone who would like to answer it. My mediation agreement wording, and I suspect many other mediators have very similar wording, says something like, if both parties agree, I can be called upon to give a decision on a particular issue. Now, I discourage that when I'm sitting as mediator, and it rarely happens, but it's there in the wording. Does that mean that I'm no longer a person because it's there as a theoretical possibility in the agreement that the parties have both signed up to, that I'm no longer a person lacking the authority to impose a solution? So it's not free from difficulty, and I don't know the answer. I mean, in the particular case, I'm not going to impose a solution until both parties agree to ask me to do so. But it's there as a theoretical possibility. Might that take me outside the definition of mediator under the convention?
Right.
I don't know.
And if I think we're going to pass on, except that Wai-Pong has got something to say about it. Go on.
Yeah, I like to jump in because that's always a hot button talking point between Jonathan and myself. You know, I mean, this is two camps of methodology. One facilitative, which, you know, if you to hear it from people in Singapore, UK, that is the dominant. But you know, in a lot of Asian cultures, the more evaluative form of mediation, which often the mediator will throw up a solution and impose it on the parties, that is often accepted as the proven way to do it. And so really, I see that in the evaluation of mediation, we're trying to find this good intersection point between the two. And that really is a good reason for interesting and stimulating talk on how mediation is going to evolve in the future. Is it going to be purely facilitative, which is the area which both Jonathan and I practice? But we would be...
That's very helpful. I think that those who are listening to this event may now understand one of the logistical reasons why we were not able to combine your treatment of the Singapore Convention with a full-blown debate on evaluative and facilitative mediation, because you can't get into the necessary time. So I'm going to say I'm noting that, Jonathan and Wai-Pong, and that's really very helpful, and it's good that we should know that there's an issue there. And so I'm going to go back to this question of the what I call history and international consensus. I mean, we do have in this company one past master who is sufficiently switched on about the Singapore Mediation Convention that all his correspondence group were treated to news of the development about Brazil recently, adding itself to one of the supporting countries. The rest of us were, I think, some of us still asking the question, so what? So when it was open for signature, we've dealt with how many signatures there were, and we've dealt with the timescale, which is basically within the last 5 years that it's been moving forward. But are there any other basic details about the history that we need to know about? And can I move on to say, as it were, why does it matter? What happens about a settlement agreement that is concluded in a convention state? Why does it need to be recognized and enforced? And why does it need a mechanism for this? Can you not just simply say, well, they agreed it, so let's just enforce it? Jonathan, perhaps.
Well, that's very nice, but I think they agreed it, so let it apply. But then there was an initial contract under which the dispute arose, which almost certainly one party will argue was not respected by the other. So why should there be now suddenly faith that simply a second contract, the settlement agreement, will be respected? So enforceability of the agreement is a critical thing. I mean, many people would say, many members of what's called the mafia, which stands for More Arbitration for International Arbitrators, many of them would say that what propelled arbitration to pole position on the international scene was the New York Convention.
Yes.
Precisely because now arbitration agreements are more widely enforceable than any court judgment anywhere. There is something over 160 states which have signed up to New York. So clearly it was something missing in the international mediation world, the question of enforcement, and that's precisely what the convention, the gap it sets to plug. But it's more liberal than New York in some respects. For example, there is, if tomorrow I make a mediation I'm conducting results in a settlement agreement, my understanding is that that settlement agreement could be now recognized and enforced in Singapore and in other countries that have signed up to the convention. So there is, importantly, there's no need for the settlement agreement to be drawn up or entered into in a convention state for it to be enforceable elsewhere. And that's a really important point.
Yes, I totally agree with that analysis which Jonathan has provided. And yeah, I think we need to propagate this effectiveness, which is is a bit nuanced, you know, for those who don't really appreciate the full magnitude of it. But it really enables the enforceability of the Singapore Convention, you know, of mediated settlements to a much larger audience than might on first blush reveal. So that really, I think that's really a good point to bring up.
Can I ask one specific point, which may be helpful because it can be a particularly a mechanism that it needs to be used. Can a settlement agreement pave the way for a stay of proceedings?
Yes, of course.
Jonathan, any comments on that one?
Yes, you have specifically, by the way, the authority, if you like, for the proposition that you don't need your settlement agreement concluded in a convention state is Article 3, Rule 1, which says each party to the convention shall enforce a settlement agreement in accordance with its rules of procedure. So it doesn't have to be, there's no restriction to agreements entered into in a convention state. That's the authority for that. The question of a stay, that's under Article 3, Rule 2. A dispute arises concerning a matter that a party claims was already resolved by a settlement agreement. A party to the convention shall allow the party to invoke the settlement agreement in accordance with its rules of procedure to prove that the matter has already been resolved. So if we have my mediation settlement agreement concluded in London, and let's say Wai-Pong is the paying party under that agreement and has his assets in Singapore, if he starts court proceedings in Singapore, disregarding the settlement agreement, then the other party, well, assume I'm the other party, I wasn't the mediator, I'm the other party, I could go to the Singapore court and say, please stay those proceedings, this is dealt with under the mediation settlement agreement, which, by the way, please now recognize and enforce.
Right. Well, upon that basis, that sounds as if it's going swimmingly. So why do you think the EU is not progressing this? And why do you think that the UK or England and Wales hasn't ratified yet? Has there been any actual pronouncement on it? I don't think there has there?
I don't think so. There may have been a working group set up. Steps may have been started for a consultation process in the UK, but that's as far as it's gone, if at all, to the best of my knowledge. What might be the reasons for that? Well, it's frankly, I think it's a little bit depressing in a way. You know, we've gone from a situation where Britannia ruled the waves and the sun never set on the British Empire, to a situation where the sun hardly rises on what's left, and our beloved government doesn't seem to be able to raise its eyes above the parapet of Brexit and COVID and such issues. And I think it's simply, you know, we see other signs of that. We're in a mess with Lugano Convention, for example. You know, why wasn't that thought through in advance? It's rather important for court judgments. But no, I think the eye is simply off the ball, and it seems to me really rather important, because still today, I think London is still the preeminent centre worldwide for the resolution of international disputes. And, you know, it's absolutely centre stage for that purpose that we have to have, you know, the right rules in force. And this convention is very much part of that.
I'm following that.
Quite apart from that, what Jonathan is not disclosing is that he has a personal interest in this, because we have an agreement that for every month that the UK delays in signing, he owes me a lunch when I visit London. So, you know, the account is rapidly building up in my ledger. So he's absolutely concerned. I think he may mount a one-man crusade to push the government to doing something to minimize his lunch exposure, and nothing else.
I mean, you also raised the question of the EU. I really don't know for sure, but there could be a competence issue. Is this a matter for the EU to ratify on behalf of the EU as a whole? Is it a matter for individual member states?
Yes.
One has to say that the EU is very pro mediation. There are several EU mediation directives.
Yes.
And there are a number of EU member states which are very pro well, particularly pro. In Italy, for example, mediation is mandatory.
Absolutely.
So why, I don't know the answer, but there may be a competence issue which is bogging things down a bit.
Right. Now,
I heard some whispers in the same vein. I mean, I can't confirm, but yeah.
I'm going to come now, because we've got a particular question that I'm very keen to get to, which is from one of our audience who's here with us, Trevor Harrison. Thank you, Trevor. Would you mind if I just simply read out the question that we have? Yes, I'm seeing a thumbs up sign. Notwithstanding the advantages offered by the Singapore Convention, is there nevertheless a useful role for a very low-cost form of structured dispute resolution, even if it's not covered by the Convention? If so, what form could or should such a low-cost solution take? Who of you, Wai-Pong or Jonathan, would prefer to start off on this one?
Well, may I just say Wai-Pong should, I think, deal with this, because he is the grandfather of what is being alluded to, which Trevor also has a particular interest in, as do I. So over to Wai-Pong.
Thank you, Wai-Pong.
Actually, such a solution does exist in the form of scribe, which is acronym for Small Claims Resolved by Experts, and this is a child of my imagination, and roping in my good mates, both in Singapore and in London. We are a team of 10, and it's actually a adjudicative process, very low cost, 3,000 Sing dollars for claims up to 50,000 US that parties can submit themselves to a limited hearing with no legal representation. The parties represent themselves, and they bind themselves to the decision by consensus, and they're on the way. And there's some merit to this, because actually in Singapore, I adjudicate very regularly at our finance institution dispute resolution center, or FIDREC, and they have a very similar process for disputes arising in the finance industry. And I see this being mirrored in the maritime community, where parties can submit themselves to a decision, a binding decision by consensus by the disputing parties. And again, it's consistent with the societal values of trust, respect for each other, and also this thread that runs through to many of the business relations, restoration of frayed nerves, perhaps some anger, some sense of misplaced justice. And I like to think that access to justice is important, and having a full suite of applications so that there's a bespoke solution for every kind of disputes. And I think classifying them by quantum is one way to have effective alternative dispute resolution without resorting to the courts. Because we know when we go to court, it can be very time consuming. It's very adversarial, as I've highlighted before, and it's winner take all. And this is not often consistent with the aspirations. I don't want to use the word values, but the aspirations of parties, in that when they have a dispute, of course, to feed the ego, one always likes to come out of it on a winner take all basis. But I think on longer reflection, restoration of relations with each party getting some stake out of the dispute is often more constructive. So yeah, I mean, Scribe, along with what's happening at FIDREC, all these creations, injected into our society to meet those aspirations. We charge very little, but I think we give parties the hearing that they wish, an oral hearing.
Yes. I'm going to go straight, if I may, to Trevor, because having contributed the question, Trevor, thank you very much. Have you got anything to add on this?
Not really. I hadn't fully appreciated that by virtue of a solution like Scribe imposing a solution on the parties, it would automatically take itself outside the Singapore Convention. On the other hand, if you've got a low value dispute, are you going to want to have to run around the world looking to enforce in overseas jurisdictions? And the whole point of a lot of consensual dispute resolution is that you embark upon it in the first place in the expectation that the other party will honor the outcome. And I wonder, in some ways, almost if the Singapore Convention doesn't go against that underlying principle. And that maybe is another topic for consideration.
Right. Thank you very much. Anything more in light of that, Jonathan, because you rather left it to Wai-Pong and indeed Trevor.
Yes. Make an agreement in good faith, hope that it will be respected by the paying party, but have the reassurance, if it's not, that you've got the Singapore Convention to give it some teeth. So I think that's reality, and I think therefore that you know, Singapore Convention is important, but I would, if I may, just like to say a word about one of the reservations, one of the possible reservations that a state signing up to this can put in. That's under Article 8, and it is that the state shall apply this convention only to the extent that the parties to the settlement agreement have agreed to the application of the convention. Now, that strikes me as, and it's on a similar theme to that touched on by Trevor just now. How extraordinary, if one goes back to the example of the mediation that I'm just concluding in London, and let's say Wai-Pong again, he's the defendant and he has he's the paying party and he has his assets in Singapore. Wouldn't it be almost extraordinary that the UK, let's say, has ratified, but it's done so on the basis that that reservation applies, namely convention only bides to the extent that the parties have agreed to the application of the convention. So that means, of course, if I had my wits about me as the claimant, I would have had to ask Wai-Pong specifically, do you agree the convention will apply? Because otherwise it won't apply as I read that reservation. So it's just an important point of detail for a party who wants to invoke the convention, just to, but when you're drawing up that settlement agreement, to make sure that you've bought into it.
Right. I'm going to, if I may, come to what I think we started out asking ourselves, what is the point of this? What is the use of this? And in particular, you had mentioned the New York Convention in terms of arbitration. So my question to you, Jonathan, is, do you think, will the Singapore Convention do for mediation what the New York Convention has done for arbitration?
Well, I certainly hope the answer is yes. And there have been surveys, you know, there are lots of these surveys of different of arbitration around the world, also dispute resolution procedures more widely. I used to sit on something called the City UK International Dispute Resolution Working Group, and there's no doubt at all that enforcement is one of the key issues you're looking at, because otherwise you simply end up with perhaps a Pyrrhic victory. So the fact that there is now enforcement catered for in the Singapore Convention, I think gives us every hope that mediation will become increasingly popular as for disputes, for international disputes, with the comfort that then you can take your agreement to the country where the paying party has his assets and get the agreement enforced. So yeah, I think there's every reason to be confident that international mediation, international commercial mediation will become an ever bigger force. And we can't call ourselves the mafia, but what it doesn't trip off the tongue quite so nicely, the MMFIA, more mediation, MFIM, more mediation for international mediators. Yeah, there's a prospect of that.
Well, I suppose on the basis that nothing succeeds like success, that might drag Europe, the UK, England and Wales along in its wake, so that might be helpful. But that's possibly a slightly facetious remark. Wai-Pong, you had a comment on this.
Yeah, I mean, really the whole effort in Singapore, we're hanging our hopes on that the Singapore Convention will do for mediation what the New York Convention has done. And I think, I may not speak for Singapore, but I think it's so encouraging that, you know, so quickly after the signing of the convention in 2019, just 2 years later, you know, we've garnered 54 signatories, about, you know, 1/3 of what the New York Convention took to achieve since 1958. So I think I speak for many that we are full of hope that that mediation will take traction. In the past, it's always been playing second fiddle, if you will, to arbitration, consigned mostly to satellite disputes as opposed to the main disputes. And that missing link was always enforceability. The survey by CIDRA actually affirms that belief, that perception. And now with the convention in place, my projection, I believe, is that it's only a matter of time before mediation will take its rightful place, although it's not adjudicative by nature. So some might suggest that it's not truly a legal solution compared to arbitration, but it has its own merits and it's accepted by the courts as standing, you know, independently on its own limb, has its own right. So we see a sort of trifecta, if you will, of the courts, arbitration and mediation, all having some form of equivalence. And really, I think the approach to dispute resolution going into the future is one of sophistication, where parties will have to assess for themselves what is the right fit for their dispute resolution. It could be any one of them acting individually or combining them in a hybridized version, acting in concert. And I think that's what's so exciting for us going forward, is that we are open and we are receptive, and we hope that, you know, parties will embrace this same confidence as we do.
Well, thank you very much. Wai-Pong, I mean, the situation does look hopeful. As a mediator, I would say that, but I think it does. And that is good to know. And in fact, it is interesting to see we've had 2 contributions in our chat from Geoffrey Beresford-Hartwell. Thank you very much, Geoffrey. You produced the second of them, was the almost gnomic utterance, "Are there victories in mediation?" So I think we could continue for some hours on that point. So if I just acknowledge your very kind question, I'm going to ask if there are any other questions not in the chat that anybody would now like to put to our 2 speakers. If so, can you wave a hand because I shall see it. Right. I think are you, Jim, are you waving a hand or are you saying goodbye? There we are. Has anybody else got a question? No. I think that this is because our speakers have dealt so brilliantly with a huge array of topics which have arisen under the Singapore Convention, and we are very grateful indeed to them, particularly to Wai-Pong Lee, and I'm conscious that if it was late before, it's even later now. So thank you very much.
Welcome.
I'm very, very grateful to you for joining us, because you have, as I think everybody will have seen and will agree, a particular perspective on this, which is of huge value. And I'm very grateful to you. I'm also grateful to Jonathan. If I may say so, the trailing of most impressive legal knowledge has been a feature of this session. And so I'm very grateful to you, Jonathan. You really have shed light on a lot of things that a lot of us will not have been aware of before, and otherwise just made a few of us sort of limber up to interesting legal points that we can seek to argue on another occasion. So thank you very much. And thank you everybody who has been with us this evening. It has been a fascinating topic. I'm delighted to have seen so many of you attending this. It's our last one, as it were, of the academic year, and moving from the from one end of the spectrum to the other. We will be moving from this seminar on mediation to the next seminar, which will be on the 19th of August, about the sub-postmaster scandal, and past Master Linnell, with her particular expertise, will be telling her about it. And Wai-Pong, if that is a mystery to you, it's a scandal to us, and Jonathan can tell you all about it some other time.
Margaret,
during one of the lunches he owes me.
Yes, Margaret, I did ask if I could just make a couple of concluding remarks.
Well, that's the point. I'd like you to finish, if you don't mind.
Okay.
Okay. Because what I'd like you to do is...
But I won't talk about the postmasters or mistresses, I promise.
I'm now going to withdraw and be quiet. I'd like, I mean, I'm not going to actually disappear, but I'd like you to finish on the same elevated note about where you think we should be going and what you think we should have learned from this evening. Thank you very much.
Well, thank you, Margaret, for hosting this. And I'm sure I speak for Wai-Pong in extending our thanks to you and to all of you who've attended. It seems to me the Singapore Mediation Convention is a force for good. According to Chief Justice Menon of Singapore, it will herald a golden age for mediation, and I would say amen to that. Now, hopefully we're coming out of the pandemic, the world that is, not just the UK. And what are the takeaways for dispute resolution? Well, I think a first point is that there are bound to be more disputes due to disrupted supply chains, delayed payments, and other operational and economic difficulties. It's a given that adversarial dispute resolution methods involve high expenditure of both time and cost. And not only that, but they risk alienating the very business relationships which are critical, going to be critical for business recovery. And even if you win in today's climate, there's no guarantee that your counterparty will be able to pay. So if not before, then certainly in today's circumstances, the interests-based approach of mediation is especially essential to help individual traders and companies get back up on their feet and ensure an economic recovery. A second point I'd make is that the pandemic has taught us that we can successfully conduct our mediations online and virtually. One of the protocols encouraging virtual mediation, it was a Singaporean protocol, says this, and I quote, "The pandemic has severely impacted business communities, fracturing business and contractual relationships, sparking disputes and destroying the value and viability of businesses. With expedited mediation, meaning virtual mediation, businesses can devote their resources towards navigating other challenges instead of diverting them to conduct potentially protracted and expensive legal proceedings. This will put them in a stronger position to recover amidst the growing economic uncertainty. So not only will there be more mediation, my first point, but there will be more affordable mediation due to the fact that mediations can and are being conducted virtually, avoiding the need for the claimant from Beijing and the defendant from Rio de Janeiro, with perhaps a third party in Hamburg, flying into London for a one-day mediation hearing. And I'm sure Wai-Pong can vouch for the fact this is not as far-fetched as it may sound. So the Singapore Mediation Convention offers the certainty that the settlement agreement reached, and according to the CEDA biennial audit, something over 80% of mediations do result in settlement. In fact, I think their last report concludes it's closer to 90%, something over 70% on the day, then 15 to 20% within a measurable period after the hearing, a settlement is achieved. So the Singapore Convention, I think, gives every chance that mediation will, as arbitration, come to enjoy center stage for the resolution of international commercial disputes. And it's in this situation that I frankly find it almost lamentable that the UK, still, as I say, ranking as the preeminent dispute resolution centre, or London, that is, as part of the UK, doesn't seem thus far to have made any move to ratify the convention. And my plea, therefore, in closing, is that those of us who feel the same way should perhaps make our representations to the Ministry of Justice to, with a little alacrity now, change the position, bearing in mind that, you know, the three biggest economies in the world, or three biggest states in the world, the US economy, China, India, most recently Brazil, have all signed up to this convention. And frankly, it would be a shame for us to be left in their wake. Thank you. That's all I proposed to say. And thank you for coming along.
Thank you very much.
Thank you very much for having me.
Delighted, our pleasure. And goodbye and good evening, everyone. Thank you very much.